This episode's will battle is over the words nephews and nieces used in a will. In this case, the deceased, Peter Wales, left his estate to the children of his nephews and nieces. The question was whether he was referring to the children of his blood nephews and nieces, or if he meant to include the children of his wife's nephews and nieces as well. You would think that would be an easy question to answer, but words aren't always given their natural meaning in will battles. The judge is always more concerned with understanding the intentions of the deceased. Given that the deceased made 3 or 4 previous wills, all in similar terms as his wife, the judge decided that the situation warranted going outside the natural meaning of those words. At stake was an estate worth just over £620,000. If it went the way of the blood nephews and nieces, then the estate would be split 7 ways, giving each beneficiary just over £89,000. And if the judge went with a definition that included the wife's nephews and nieces, it would be split 15 ways, meaning that each beneficiary would get just over £41,000 each. So how would it play out? Would the natural meaning of the words prevail, or would the judge prefer to take other evidence into account? Case history continues in just a moment.
Is your family being ripped apart by an inheritance dispute? Are you about to squander your inheritance on legal fees? Wait! Why not try mediation instead? It's a great way to resolve inheritance disputes. You get a result that works for you, and you rebuild family relationships. Plus, you save thousands of pounds on legal fees. Best of all, it only takes a day, so you save months and years of litigation. Mediation saves money, saves time, and heals family rifts. No one loses, and everyone's a winner. Go to remyayela.com/inheritance-disputes to get started today. Online mediation is available.
The claim was brought by the claimants, John and Andrew Wales, as the executors of the estate of the late Peter Wales, who died in February 2015, a widower without children. By Clause 7 of his last will, made in December 2008, the deceased gave the bulk of his estate to all of his nephews and nieces' children. The executors asked the court to determine whether the estate should be divided between the children of the blood nephews and nieces of the deceased, or between them and the children of the nephews and nieces of his wife. The deceased was married to Wendy, who died some years before him. By the time she died, they had been married for 46 years. They had no children of their own. The deceased had 4 blood nephews and nieces, who between them had 7 children. There are therefore 7 children of the blood nephews and nieces. Wendy had 5 nephews and nieces, who between them had 8 children. That means that there are 8 children of Wendy's nephews and nieces. The deceased and Wendy both made mirror wills in 1967, 1988, and 1997. In each case, these wills were professionally prepared by solicitors. By his 1967 will, the deceased left his estate to Wendy. In the event that they had no children, other than a few small cash gifts to his and Wendy's siblings, he left his estate to various charities. Wendy's will was the same as that of the deceased. By his 1988 will, the deceased left his estate to Wendy. If she didn't survive him, again, other than cash gifts to his siblings, his wife's nephew, and the children of one of her nieces, he left his estate to 2 charities. Again, Wendy made the same provisions in her own will. By his will of 1997, the deceased gave his estate to Wendy, but this time, if she didn't survive him, his estate would be divided equally between his nieces Suzanne and Fiona and his nephews Andrew and John, as well as his wife's nephews John, David and Hayden. As before, Wendy's will was identical to that of the deceased. Some 8 months after Wendy's death in April 2008, the deceased made his last will. Apart from cash gifts to some charities, he left his estate to the children of his nephews and nieces living at his death. The question for the judge was, what did the deceased mean by my nephews and nieces? The judge accepted that when interpreting the wills, it's usually a question of identifying the meaning of the words in the light of the normal and ordinary meaning of those words. But in addition, he said, in an effort to find out the intention of the deceased, the court will look at the overall purpose of the document. This includes looking at how the provision relates to other provisions in the will and the facts pertaining to the matter as far as the deceased knew it, and also according to common sense. In effect, said the judge, the court has to place itself in the armchair of the deceased. That means that the court will allow evidence of what the deceased had intended if that is helpful to interpret the provision. In a previous case, the terms nephew and niece were interpreted to have the strict and proper meaning of those words, that is, son or daughter of a brother or sister. However, the judge said the meaning could be extended to take account of the context and circumstances of the case. Although in that case the court gave the words their ordinary meaning, the judge did point out that the word nephew is often used to indicate a niece's husband, and niece is often used to describe the wife of a nephew. So it's a question of what the deceased intended. After reviewing that case, the judge formed the view in this case that the previous wills made by the deceased and his wife were all part of the surrounding circumstances and were part of the background against which the deceased made his last will. The previous wills show that throughout their marriage, and especially after it became clear they weren't going to have any children, both the deceased and Wendy made similar wills by which whichever of them was the survivor left a gift or share of the residue of the estate to both sides of the family. A further part of the background is that on Wendy's death, the deceased had inherited the whole of his wife's estate. The only changes the deceased made to his will after her death was to make some small monetary gifts to some charities, and then with the rest of the estate, he simply skipped a generation in favor of the children of the nieces and nephews. In looking at the history, the judge said there was no tangible evidence to explain why the deceased would have intended to change his will so as to exclude all of Wendy's family, especially since after Wendy's death, her family continued to visit or call the deceased until he died. The judge made his decision taking the following evidence into account. 1. A marriage between Wendy and the deceased which lasted 46 years. 2. The previous wills of both Wendy and the deceased. 3. Passing of the whole of Wendy's estate to the deceased. 4. The absence of any evidence as to why the deceased would have wanted to exclude Wendy's family. And 5. The continuing contact between the deceased and Wendy's family in the months and years after Wendy's death. The judge said it was clear that the deceased, by referring to all of my nephews and nieces' children, must have intended to include nephews and nieces both by blood and by relation to his wife. The deceased had indeed intended to benefit both families, so the estate should be split between the children of both sets of nephews and nieces. This would mean a 15-way split, giving each beneficiary just over $41,500 each. The judge pointed out that this will battle was caused by the will maker failing to take the time to ask detailed questions about the intentions of Mr. Wales. There are many lessons to learn from this case. First, if your new will makes different provisions from your old will, you should make sure you explain in a side letter why you made those changes and keep that letter with your will. In this case, Mr. Wales could have explained that he had decided to include his wife's nephews and nieces and give his reasons, or that he didn't want to include them, again, give the reasons. Leaving a letter that explains your intentions and the circumstances behind your decisions allows you to speak from the grave. Otherwise, it's left to the judge to try and figure out what you intended. And the judge can only make his or her decision based on the evidence. If there's no evidence to say one way or another, then your wishes may not prevail. So leave a letter of explanation whenever there's an ambiguous provision in your will. Or better still, try not to leave any room for ambiguity in your will. Be clear and be precise. On the issue of being precise, be sure to define family relationships, and if you're not sure, do what the judge recommended, which is to draw a family tree that shows exactly which family members you intended to benefit. Be sure to join me again next time for another case history.
This is Family Wealth TV. Don't forget to subscribe and hit the notification button to be notified when we upload new videos.